We will get underway now. Thank you for joining us today. My name is Sarah Flannery. I am a partner in Thompson Hine's immigration practice. I have the privilege of co-presenting today with my partner, Staci Jenkins. We both practice exclusively in Thompson Hine's immigration practice. We welcome you to today's webinar. This is the fourth in a series of webinars examining what the change in presidential administrations could mean for the country. Before we begin, a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. If you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen to submit questions. We will answer as many of the questions as we can at the end of the webinar. We will be offering CLE credit for today's webinar. Please be sure to fill out and return the webinar affirmation form that can be found in the handout section of the control panel located on the right-hand side of your screen. The form provides instructions of where to send the completed form. You will need a tracking code, which will be announced at the end of the program. In the handout panel, you can also download a copy of the PowerPoint slides and the bios of today's speakers. Again, thank you for your interest. And if you have any questions as we go along, please use the question box. We have organized the presentation today that I will kick us off with our discussion from more of a high level around different approaches to immigration generally between the Trump administration and the Biden administration. What actions in the first 2 weeks highlight priorities for the Biden administration? And then Staci will turn to some of the specifics and in particular issues that face employers in employer-sponsored immigration. Our practice at Thompson Hine is focused on employment-based immigration, and so we will address a lot of the issues that would be of highest importance to employers, but we will also touch on some of the broader changes in the immigration space. So if we look at immigration priorities and philosophies of the Biden administration as our starting point, President Biden laid out in a fact sheet that the White House published on February 2nd of this year in connection with some of the executive orders in the immigration space, what his strategy is. And I'm not going to read the strategy. It is here in the PowerPoint slides, but you can see here that it comes from a positive perspective, welcoming immigrants, wanting to keep families together, acknowledging a view that foreign nationals immigrating to the US can fuel our economy and create jobs. This is in contrast to the broad perspective that the Trump administration had on immigration. When you look here at some of the action steps taken by the Trump administration, even just in the first year of the presidency, it was banning foreign nationals from certain countries, canceling the DACA program, which is for the group called the Dreamers, reducing refugee, ending some of the temporary protected status for certain foreign nationals. And so what do some of the actions taken in the first 2 weeks show us about the priorities of the Biden administration on immigration? Because the actions taken in the first 2 weeks, first actions equals first priorities. So beginning on Inauguration Day, there were three actions that came about on Inauguration Day. 2 are here, and then the third on the next slide. So here, one of the actions that President Biden took on day 1 was to direct the Department of Homeland Security Secretary, in consultation with the Attorney General, to preserve and fortify DACA. Now, when President Biden came into the administration, DACA was in place. And the reason why it was in place is that the Supreme Court had ruled that the way in which President Trump went about trying to dismantle DACA was not going to work. The Supreme Court did not say DACA cannot be dismantled, but it said that the way that President Trump's administration went about doing it was not compliant with the rules that are required. So the Supreme Court did leave open the possibility that DACA could indeed be dismantled through executive action. And so what President Biden is saying is we need to get this into a position where it will be protected. And that was a day one priority. Another day one priority was President Biden reversing the travel ban that had been referred to as the Muslim travel ban. This is a travel ban that President Trump, it took him 3 iterations to get to a version that was upheld by the Supreme Court. And it limited travel from countries, many of which are Muslim majority countries. And President Biden reversed this travel ban on day one from a viewpoint of it was discriminatory. The other big action on day one was President Biden sending to Congress a comprehensive immigration reform bill called the U.S. Citizenship Act of 2021. Now, the text of the bill has not been released, so we do not have the details in and out of everything in the bill. What we do have is a fact sheet that the White House published to provide the highlights around the bill. And there is a link here to the fact sheet itself that you can access, and we will cover some of the highlights. The sort of anchor provision that is getting a lot of press coverage is to create a pathway for undocumented individuals to get both legal status and then the ability for a green card and then a path to citizenship. Now, under the fact sheet, not all undocumented individuals are treated equally. There's 2 categories that the fact sheet lays out, and there's different timelines for those 2 different categories. The category that has the more preferential treatment includes the dreamers, which are the individuals who have been protected under DACA, those individuals who have the temporary protected status, and farm workers. Those 3 individuals would be eligible, according to the fact sheet, to apply for a green card upon the passage of the bill. All other undocumented individuals who are in the US would have a pathway to apply for temporary legal status, assuming that they pass things like a background check, etc. Then they would have to hold on to and maintain that temporary legal status for 5 years, and then they would be eligible for a green card. So the dreamers, the TPS individuals, and the farm workers can go immediately to a green card. All other undocumented individuals have to hold a temporary legal status for 5 years before they can get to the green card. But then once at the green card stage, the wait time to then become eligible for citizenship is only 3 years, as outlined in the fact sheet. What's interesting about that is that would put this group of individuals on the same priority level as spouses of US citizens in terms of the wait between the time of getting a green card and the time of becoming a citizen. Whereas most employment-based green card holders have to hold on to their green card for 5 years, before they can apply for the citizenship. So that would be interesting to see how that would maybe be negotiated in Congress. Some of the other provisions that are in the U.S. Citizenship Act of 2021 are calls for clearing the backlogs for both family and employment-based immigration. On the employment-based immigration side, some individuals, Indian-born citizens, for instance, may have a 10-year wait between the time their employer starts their green card process and the time they're able to get a green card. And that 10-year wait has real implications for both the employee and the employer, because it can tend to restrict both the upward growth of the associate within the organization and then certainly the mobility of that individual to move to other employers. So the backlog would be a welcomed advancement for both workers who are going through the process, but also for employers who want to be able to have upward mobility of these individuals whom they've identified as high value resources they want to invest in and sponsor them for the green card, and only to have to wait 10 years to get that for them. Other calls for change that are in this bill is easier path for graduates of U.S. universities with advanced STEM degrees to stay in the U.S. There is not detail around what that would look like. Might that be expanding the number of H-1B visas available? Might that be expanding the OPT that is currently available? We don't know what that would be yet. There is also a call for improving access to green cards for workers in low-wage sectors, and also a $4 billion investment in trying to solve some of the root cause issues that are pushing up the need for asylum and refugee largely. So looking at what are some of the root causes in Central America that are causing individuals to want to flee, and can we counter some of those root causes? If we move past Inauguration Day and into the first several days of the administration, on January 25th, there were executive actions put in place by President Biden that impact immigration. The first was to issue a proclamation around travel bans that are COVID-based. So the history with this is, initially, this travel ban was put in place by Trump in the spring of 2020. President Trump extended it in December. It was set to expire December 31st. And, a couple days before it was set to expire, President Trump came out and said, this needs to be extended. We're extending the travel ban. Then in the last few days of his administration, President Trump announces these travel bans can be lifted. And on January 26th, there will no longer be a travel ban from Schengen area, UK, Ireland, and Brazil. What President Biden did was on January 25th, he said, nope, these are going to stay in place. COVID is still spreading. There's now even variant strains being detected. We are not going to open up these travel borders like this. He added a new country for a travel ban, and that is South Africa. So currently, you cannot travel from these countries into the US. If you've been in these countries for 14 days prior to seeking entry, then there's the travel ban. Now, China and Iran are not listed here. There is still a travel ban from those areas. The reason why it's not listed here is President Biden didn't need to address those travel bans because President Trump did not try to lift those ones. So the only ones that President Trump was going to lift lift were these here, and so President Biden was forced into taking action on those. The other executive action put in place on January 25th was an executive order titled "Ensuring the Future is Made in All of America by All of America's Workers." There really is not a lot of immigration content in here, but there is one provision, and what it does is it revokes an early executive order that President Trump did in his administration, which was titled "Buy American, Hire American." And in President Trump's "Buy American, Hire American" executive order, he called for there to be changes that would limit number of H-1B visas, try to impose higher wages on the H-1B visa program. So that Buy American, Hire American executive order came out in 2017 in President Trump's early administration days. It didn't get action really until the end of his term, when all of a sudden there was a proposal for higher wages, and Staci will talk about that and what's the status of that when we transition to her. Moving forward to February 2nd, this was Immigration Day for President Biden's administration. So the way that the administration had sort of organized their early weeks was to pick certain topics for certain days. And on those days, they would roll out, what is our plan for X? So there was a day for COVID, a day for immigration, etc. February 2nd was Immigration Day. And some of the actions that took place there are, first, the Senate did confirm President Biden's nominee for Department of Homeland Security Secretary, Alejandro Mayorkas. So he is in place as DHS Secretary. There were 3 executive orders that were issued on February 2nd, and they don't really bring about the change that many in the immigration space were hoping for. They call for change, but there's not a lot of immediate action that grows out of these executive orders. We do have links here to the 3 executive orders. The first, on the establishment of the Interagency Task Force, this is putting together a task force that would reunite families that were separated at the border, and it revokes President Trump's executive order that sought to justify that policy of separating children. The second one is where a lot of change might grow out of, but we just don't know what it will be. So this executive order calling for restoring faith in the system calls for a top to bottom review of regulations, policies, and guidance that have created barriers to the legal immigration system, and orders an immediate review on agency actions relating to one particular barrier, which could be the public charge admissibility. So what this might look like could be, there was a change in policy under the Trump administration where all employment-based green card applicants had to go for interviews and sit across from an immigration officer to answer questions. And that has delayed processing. It creates an additional burden on the immigration staff. That might be removed. It wasn't in place before the Trump administration. Maybe they would go back to employment-based applications don't require that. There was a memo during the Trump administration that said the Immigration Service will no longer give deference to prior approvals. So the fact that you secured an H-1B approval in the past does not mean that we will give you an extension today. That might be something that would get rolled back and return to a state of having confidence. If the Immigration Service approved this once and all of the material facts remain the same, we should have confidence that we will be able to continue to employ this person and the H-1B will be extended. There also has been a lot of frustration with the requirement that the USCIS put in place under the Trump administration to require biometrics for all family members of temporary employees under temporary work visas. So the spouse of an H-1B worker, in order to renew his or her status, has to go and get their biometrics taken. The spouse of an L1 worker, same thing. It delays the processing, and it also creates an additional processing barrier that delays the petitions. That could be something that might be rolled back. The last executive order relates to the southern border and the asylum system. Finally, on February 3rd, so a day after Immigration Day, the USCIS did actually implement a change of a previous policy. So that call for the top to bottom review might occur a little bit faster than anticipated. On February 3rd, USCIS went back to a approach that was outlined in a memo in 2000 that said computer programmers are individuals who will generally be viewed as eligible for H-1B. Under the Trump administration, the H-1B visa category was heavily scrutinized, and the Trump administration had rolled back that memo and said USCIS is not going to view computer programmers as a traditionally eligible H-1B occupation. And there was a Court of Appeals case that overturned USCIS denials on computer programmers. And so on February 3rd, USCIS said, hey, in light of the appeals court telling USCIS that they got it wrong, we're going to rescind the policy under the Trump administration and go back to a policy of recognizing that computer programmers are an H-1B eligible occupation. So those are sort of the high priorities that were put in place quickly and some of the forecasting out for what might come. And now I'm going to turn it over to Staci to talk about the leadership changes and what still remains uncertain.
Thank you, Sarah, very much. And hello, everybody. I appreciate the opportunity to speak with you this afternoon. And as Sarah mentioned, I want to jump straight into the discussion related to the new leadership. So, as promised by President Biden's administration, he is going to implement changes on the immigration front, both policy and culture, from the top down. His first step in doing that is the appointment of these new leaders. So both individuals have a significant history with both of the agencies, and I think that's really important to point out. So first, focusing on Department of Homeland Security. On February 2nd, the Senate approved the nomination of Alejandro Mayorkas as the new Secretary of DHS. Very important to also mention, he is the first Latino as well as the first immigrant to head the agency. He has significant experience in immigration in that he previously led the USCIS. And what I think is also very interesting and important is in his very first speech, he did make certain to reiterate his alignment with President Biden's overall strategy and his overall approach to immigration when he said the United States is a welcoming and empathetic nation, one that finds strength in its diversity. So we're already seeing that continuation of commitment that President Biden outlined at the beginning of his term. I will also say across the immigration front, I think many are looking forward to what we hope is going to be a period of more stability in longer term placements in the role. So over President Trump's administration, there were two secretaries of DHS, Neither of them served more than 16 months. And we also had 4 acting secretaries in between. So we're looking forward to some longer term placements where we can see some significant action continuing on. The other leader that has also been put forward already is for the State Department. And Antony Blinken, he was actually confirmed on January the 26th. And similarly has a very long history with the agency. And he actually initially joined the State Department in 1994. He took posts with President Clinton's White House. He then served on the staff of the U.S. Senate Foreign Relations Committee. He also served as then Vice President Biden's National Security Advisor and President Obama's second in command. So with this, with these 2 new leaders, we anticipate that we are going to see a lot of new, a new culture rolling down as well as new directives rolling down. And I want to start with one of the items that, we are still seeing a lot of uncertainty though. As Sarah mentioned to you earlier, she specifically highlighted we were expecting more, I think, out of Immigration Day. There were a lot of individuals in the immigration community who were looking for different policies to actually be rolled out, different executive orders to possibly be canceled, and we did not see that from the beginning. So jumping in on the uncertainty, one thing that as early as last week, actually the final days of last week, that we did see some action on is the H-1B program. And this is something that probably impacts all of you pretty significantly given the time of year as well. So we just want to talk through where we are, what's happened over the course of the last few months, and what we envision going forward as we're approaching April the 1st. So for those of you who might not be as familiar with the H-1B process, let me give you just a little bit of background. So the H-1Bs are used for specialty occupations. We have doctors, engineers, are good examples, teachers even. It's positions that require a bachelor's degree or higher in a related role. The trick with H-1Bs is that for most organizations, they are limited in number. So there is a lottery that has to occur every year because the applications or petitions outnumber the spots that are available. And over the last few years, we've seen a lot of changes occur in that lottery process. So there's already, even before these recent actions by President Trump's administration that I'm going to mention, there was already a great amount of uncertainty over the last few years, and we might even say instability in terms of things. So for example, several years ago, and what had been the case for quite a long time, is that in order to apply for the lottery, companies would have to work with an attorney or on their own, prepare a full H-1B petition, submit that in the lottery, submit that the first week of April. Then any that were submitted would get submitted or would go into the lottery, and the lottery would be selected from those individuals. What happened then, it was very inefficient, as all of us can imagine. And for those of you who were involved in it, you know the amount of resources and time that it took, whether it was your legal teams or your HR teams. So President Trump's administration last year said, well, let's change this. And they put out a regulation actually 2 years ago, but it went through for the first time last year, that said we're going to have a registration period where everyone who needs an H-1B, the company registers for that H-1B under an electronic system, very relatively short form. And once you registered for that, after the period closed, they would conduct the lottery. You would find out if you were selected, and then you would only prepare and file petitions for those individuals that were selected in the lottery. The idea being much more efficient, you weren't having to do all of that, front end work. And I will say it went very smoothly. I think there were a lot of concerns as to whether or not that would work and if the technology would be supported appropriately. And it did go smoothly. And so I think everyone was looking forward to that again this year. Well, a few months ago, President Trump's administration put forward a proposed rule, and then it was a finalized rule, and what was one of the many that have been kind of referred to as the midnight rules going into place right before he went out of office, that changed the selection process per se, or the system. So under the previous system, it was completely random. The only factor that increased your likelihood was if you had a graduate degree from a U.S. university. Under this new proposed system, under President Trump's final rule, the selection is actually based on the offered wage, and positions with the highest wages, more specifically the highest wage levels and the prevailing wage scale, would be selected. And what was going to happen with that is that entry-level positions were going to be blocked out. They actually did an analysis. If everyone were to apply who, let's say, applied last year, and we used this theory, it meant that your entry-level individuals coming out of universities in the U.S. probably, or any entry-level positions, probably weren't going to get selected because it was going to be held for those higher-level, more experienced positions. So as I mentioned, that new rule was put forward in place and was supposed to be effective because it was published prior to President Trump removing or being, out of office. Then, though, we had a situation where President Biden has essentially said any rule that President Trump was going to put forward should be examined. And as part of that examination process, President Biden has now delayed this rule until December of 2021. The good news for all of us is that it will not apply to the April 21 lottery. And, that means we can move forward with a bit of ease over the next month and a half. But what it does mean, and what I think is very important to notice here, is President Biden's administration did not do away with the rule completely. In fact, the new rule that he put forward that will delay it until December of 2021 also does decrease those required wages a little, but it still has that overall theme that it's going to have increased wages. So we're not out of the woods yet. We still are going to probably be dealing with this and be looking at it, particularly for next year's lottery. That being said, April 1 is what's upon us. So I do just want to mention that what is going to happen, because that's the immediate concern right now. And that is the lottery is going to move forward as it did last year. And so what we know now is the following. Registration is going to open on March 9th, and it's going to go through March 25th. Similar to last year, lottery selections will be notified by March 31st. The first filing date for H-1B petitions selected on the lottery will be April 1st. Another item to keep in mind is there is a possibility for future rounds of selection like they had last year. So what happens is with this registration system, they have the first round of the lottery. If they don't end up using all of the numbers, they go back and they select a lottery again from who is remaining in that selection pool. So we did have that this year, and did receive notices of petitions that we were able to file later in the year. So merely not getting selected the first time does not mean that you are out of luck. So keep that in mind as we move forward. Moving on past the lottery, but still focusing on H-1Bs is, many of you may remember, depending on how close you are on the immigration front, you might remember there was a rule that was published in October where President Trump was trying to increase the wage levels. So he was trying to, say that the wage level would be higher, even if it's a wage level 2, that level would be higher. A 3 would be higher than the 3 was prior to that. And with that being said, he did that without giving any notice. The final rule went into effect approximately 24 hours after the published rule. And what was, resulting in that is the LCAs were requiring immediately a higher wage. In another of his, what we're going to refer to as the midnight rules, the Trump administration finalized this prior to the inauguration, meaning they went ahead and even though the rule was stopped in litigation, the October rule, they did in the month of January publish it again so that it would be effective by March 15th of 2020. And since it was published prior to inauguration, it's another rule that is set to go into place. Now, I mentioned just a little bit ago the fact that they are going to, increase those wages, and that is something that we are going to see from President Biden, where those wages are going under this new rule to still be increased. So definitely keeping that in mind as we move forward. I do want to say some things and some policies that we can keep in mind to deal with this is that the DOL with having that rule effective on May 15th, it is going to have wages that go into place at those higher levels on July 1st. So what can we do? How can we deal with that? We can look ahead at expirations and we can prepare our LCAs before July. So if you are involved in the H-1B process, you can go ahead and you can prepare the LCAs, have them ready to go, even if maybe the H-1B petition can't be filed until later in the year. So it would be worthwhile to avoid those increased wages by doing that. Another option that I want to mention, and this is where it ties very closely to the H-1B lottery cases, is even if an individual is not selected for the H-1B lottery, you may want to go ahead and consider preparing LCAs for those that aren't selected. This way, if they're selected later in the period, you can still go forward with the prior LCA and the lower wage because you have it prepared and certified. As I mentioned, though, one thing to keep in mind here, President Biden is not looking to overturn every one of President Trump's initiatives. So here he's indicated he does favor incentives for increased wages, and we will potentially see those and those requirements for increased wages moving forward. Another uncertainty that we definitely have right now is related to travel. Sarah mentioned that many of the travel bans have been lifted, but we still have several in place and we still face significant logistical challenges. So as Sarah mentioned, the bans that still exist we have some bans on employment-based visas such as Ls and H-1Bs. And there are exceptions for these, but for individuals who are getting an L or an H for the first time and even for some renewals, those bans are in place and the exceptions to those are relatively limited. So until that rule or those bans either disappear and fade out in the sense that they expire at the end of March, or until we do see action by President Biden's administration to revoke them, we still have those limitations. The other thing to keep in mind are we also have the COVID travel related bans on physical presence that Sarah mentioned, where you can't enter the U.S. if you've been in those areas within the 14 days before entry. So keeping those in mind, that limits a high number of the individuals that can enter the U.S., even though some of those, what have been referred to as, say, the Muslim travel bans and things like that have been, done away with. So even if the bans, let's say you're in the lucky group where the bans don't apply to you, we still have significant logistical challenges. And one of those is very much that the consulates have limited visa services. And in terms of how they have limited visa services, we are seeing it varies from consulate to consulate. Many of them will only allow emergency appointments. So you might have to show something as an extreme hardship in order to get that appointment. Many times a hardship on the company, sometimes the individual might be able to qualify for those depending on the situation. We're also seeing that many consulates are saying that they will only process visa appointments for those living in the country. So even if they've said, yes, we are open, they will not process them for what we frequently refer to as third country nationals. So someone who isn't currently in the country, but who would like to travel there just for purposes of applying for the visa. So with that in place, it really is very difficult to find a consulate where someone might be able to apply, even if the bans don't apply to them. The other thing that we're facing that I just think is important to note is the ever-changing COVID restrictions, whether it's quarantine, whether it's testing requirements. That is something that we see changing, as all of you know, even from within the U.S. travel. You see it changing without notice. So whether it's that a person can, yes, they might be able to process that Chile, but they have a 10-day quarantine, that might make it difficult to even consider moving forward in that path. So with that all in mind, individuals really also should not assume that if they get an appointment, it will move forward. Even if they get that appointment, that was a routine scheduled appointment, what we are seeing from consulate to consulate is that those appointments are routinely getting canceled. So they might have the appointment and then 10 days in advance be notified that the consulate is not going to be offering those appointments, and it will be rescheduled for several months later, if even rescheduled at all. With all of that said, we are at a point where we still are advising that individuals should not be considering travel. Unless they have a visa in hand that is still valid, they really face risk that if they travel, they could remain stuck outside of the U.S. for a significant period of time, even if they don't have a specific ban, such as the visa ban, that applies to them, merely just because of the logistical implications. So I do want to move on now just to kind of talk through what we anticipate and, uncertainty, but maybe a hopeful note. Some of this Sarah has mentioned, but I do want to highlight it a bit more. And it's the cultural reset, and that we're hoping to see from the top down. We're seeing it start with the leadership. We're even seeing it move forward with some of the policies that are already coming out. President Biden's press secretary stated in her February 2nd press briefing that more information will be coming. And I think where this came from, particularly in this comment, was there was an acknowledgement that people were hopeful for more. People were hopeful that the H-1B and the L-1, bans would be revoked, and that didn't occur. People were hopeful that those executive actions would have more teeth behind them, more actual changes, as opposed to speaking of changes. But what she indicated that we should all be looking for is that there will be things coming directly, particularly from the new Secretary of State and the Secretary of Department of Homeland Security, and even to the point of suggesting that questions are posed to those individuals and to those organizations, and agencies, of what is coming down the pipe. We did, as Sarah mentioned, already see the rescission of the 2017 policy memorandum that kind of put things back to 2000 related to the computer programmers and just the overall approach or similar approach on H-1B adjudication. And then in that executive order that Sarah mentioned, the Restore Faith executive order, it has essentially advised all of the agencies to look at policy memorandums, to look at policy guides, internal guidelines, and look at everyone that was initiated under President Trump's administration, and is it something that should continue, or what should be done to be more in line with this administration. As I mentioned though, and Sarah has mentioned too, we do want to be very cautious because we can't just assume that everything is going to be turned back. Things such as the promise of, an incentive towards increased wages will probably continue, and it's going to just be interesting to see to what level those are reversed and or backed off of. So the final thing, and we've mentioned some of these as we've kind of gone through, but I do want to make certain to highlight them again, are the strategy considerations for employers as you move forward. So one of the items is we do believe you should have greater confidence in the continuation of work authorization for H-4 spouses and DACA recipients. So historically, there was the proposed rule that never seemed to make it forward. It was always just in the background, but always there to create anxiety, that they were going to do away with the work authorization that H-4 spouses obtained once the H-1B hit a certain level in the green card process, or the EADs that DACA recipients received, allowing them to work. We, already can see that is turning back. That proposed rule that was sitting still, that had not been published or had not been moved forward related to the H-4 EADs is now pulled out of consideration. We've already seen the action related to DACA and the continuation of that, and then the promises of options for those individuals moving forward. We are also seeing on the H-4 spouse a potential, I don't want to say promise, but a suggestion in the proposed laws or the proposed comprehensive immigration reform that President Biden is putting forward, that H-4 spouses would be able to get EADs, employment authorization, regardless of if they've hit certain milestones in the green card process. So that's very promising and something that would open up a lot of opportunities for a large number of individuals. We also would suggest that you consider that 2021 may be the year to sponsor H-1Bs. And what we mean is it really goes back to that wage increase as well as the lottery consideration. So in terms of new H-1Bs, this is the year where we have confidence that it's still going to be random. After this year, there is that chance of the wage selection playing into the selection in the lottery as a preference. And so with that being said, it may be more difficult to obtain H-1Bs, particularly for more entry-level positions. And then going forward as well, if the wage increase regulation is finalized, where they are increasing the wage levels for all H-1B sponsorship, we would anticipate that could really make future sponsorship of H-1Bs a bit more difficult and harder for companies to reach that. So taking action prior to July on sponsorship to the extent possible, or planning ahead to maybe get in before those wage increases occur, would be very beneficial as a strategy for employers. And then last but not least, I do want to mention that, and many of you have probably seen this, that you might want to be prepared for increased requests for employees for green cards. Now, we're not necessarily suggesting that you move forward with those. We do anticipate that companies, though, are going to see those increased or requests. And the reason for that is we notice that occurs anytime when there is change on the horizon, whether or not that change is followed through with. And so the idea that there could be a difference in how doing away with the per country limitations or different things along those lines, or even a change in how green cards are obtained, tends to make employees a little bit nervous and want to move forward with the known rather than the unknown. So that is where some of the things in terms of the uncertainty that we wanted to make certain to cover. And we are now going to begin the question and answer session. We will address as many of the questions as we can in the time remaining. But before we start, if you are seeking CLE for today's program, I know this is the important thing that many of you might be looking for as well. I'll give you a chance to grab a pen. The tracking code, though, is THCLE0209. Again, the tracking code is THCLE0209. If you have additional questions after today's webinar, feel free to email or call your current Thompson Hine lawyer. If you are not a current Thompson Hine client, please contact one of us, and we will be happy to discuss with you options to address your needs. So we are going to go ahead and look. Sarah, have we had any questions come in?
Yes, Staci, here's one if you want to offer your response. With regards to seeing the wage levels increasing and being effective on July 1, are those increases anticipated to be substantial increases or more of a normal increase?
Yeah, that's a very good question. And at this point, based on the new the new regulation that was put in place, or that was recently published, it is still very significant. So we're not dealing with an increase that would be relatively minor of what you would see in a change of market increase. So for example, the level 4 wage is going to the 90th percentile instead of, I believe, the 95th, which is what was proposed under President Trump's administration's regulation. So we definitely are seeing that be a significant increase, not as significant as what was proposed under President Trump's administration, but still very significant compared to where they are now, which is why we would suggest looking at moving forward with getting any of the LCAs in that you can that are part of those H-1B applications in advance of that where it's feasible to do so.
Thanks, Staci. Another question that we have, and I'll tackle this, and if you have any additional comments you can add, is have we seen any trends with the national interest exceptions when those are being requested? And a trend that I would say is when the guidance came out from the Department of State of what would constitute a national interest exception to the bans on H visas or the bans on L visas or the bans on traveling from the Schengen area or Brazil to the US, the consulates invited people to seek those national interest exceptions. The consulate officers at the US consulate in Bern even released a video saying, if you think that you're eligible for a national interest exception, we want to hear from you because we want to start to get business travel back to the US. But then as we moved, and so the NIEs were granted pretty easily and expeditiously. During the holiday season, the processing of them became much longer because there was more travel. And then as the COVID spikes went up and as variant strains started to emerge, all of a sudden there's been denials on national interest exceptions when that exact same fact pattern was approved easily in, let's say, September. So there has been a narrowing of that, but that narrowing started under the Trump administration in the winter, and I would say that from my observation, it's tied more towards COVID than policy changes.
Yeah, Sarah, I would definitely agree with that. I think the one other thing that we've seen more clearly defined is the fact that most of the consulates now are being very strict that they won't approve the NIE request unless you are already in the country. So it raises that, we were talking about that uncertainty of travel and of even consulate appointments, raises that even more because you're not going to know until the person is actually physically present in the country if the NIE will be granted. Whereas historically, in the beginning of in that favorable time period, we were seeing that they would grant them prior to the individual leaving the U.S. and they would know and have some more comfort that they would be able to get that to come back.
Great. And then Staci, one final question. Have we seen a change on USCIS decisions immediately upon the transition?
And I would say no, not yet. I mean, we are still getting requests for evidence on a lot of the various things that we received them on before. For example, is an electrical engineering degree going to qualify someone as a computer programmer or a computer software engineer? We've seen them on, questions related to is the history of someone's employment going to meet the standard for specialized knowledge for an intercompany transferee. So we are definitely still seeing that same level of request for evidence. But that being said, as you mentioned, one of those executive orders calls out for a top to bottom review of all immigration processes and memorandum. And we would anticipate that, yes, it's going to take time for those to be rolled out, but that we will start over time, that overall culture and a bit of a turn away from an agency with a no culture to hopefully an agency of how can we help you or yes culture will come through. Sarah, did you have anything to add on that one, or should we, if there's no other questions, I can go ahead and get ready to close out things and remind individuals of that code one last time?
Yeah, that'd be great. Finishing on time.
Fantastic. We love to give people the rest of their day back. Sorry, give me just one moment. So that CLE code that we talked about was THCLE 2090.
No, 0209.
Oh, I do apologize. I'm sorry. 0209.
Correct.
Again, Sarah, would you mind giving that one more time for everyone, just in case that confused a little bit?
Sure. It's THCLE 0209.
Okay.
Thank you,
Wonderful.
everyone, for joining us. And we will distribute the recording of the presentation, and you have the slides that you're able to download. Any follow-up questions that would grow out of the presentation today, Staci and I will be delighted to hear from anyone requesting follow-up. Thank you.
And also, just to add, our next webinar in the series, Transition, a Presidential Change, going to be held on Tuesday, February the 16th at 2 p.m. The webinar is going to address potential changes at the National Labor Relations Board. So we hope you enjoy the rest of your day and stay well. We'll look forward to connecting with you in the future.